My name is Martha Minow, and welcome to the first in a series of discussions of the COVID and Law Colloquium here at Harvard Law School. I give my thanks to John Manning and so many members of the Harvard Law School community for making this colloquium possible, and to my partner in this effort, Emily Broad-Lieb. This session is recorded. Emily and I developed this forum as a discussion format for addressing the many ways in which legal rules and issues, as well as practices and institutions, are tested and illuminated during this pandemic. Law is implicated as both a resource and as a problem. There's a way in which the pandemic shines a spotlight on the inequities, frailties, and failures system-wide in all of our social institutions, and that includes legal institutions, especially inequities falling hardest on members of marginalized communities. Notably, many people of color, many people who are impoverished, are experiencing not only health challenges in a disproportionate level, but also legal challenges and failures of legal systems to assist them. Over the course of this fall, this weekly colloquium will involve over 40 members of the Harvard Law School faculty and staff in discussions supported by a blog that itself is overseen by some students. And we will address such basic questions as who decides whether there are stay-at-home orders or requirements to wear masks or mandated vaccines. How is healthcare distributed? What about approval of drugs and vaccines? Contact tracing, is it required, is it permitted? Food systems, supply chain, the health and safety regulations governing meat packing plants, the delivery of subsidized student meals when schools are not meeting in person, distribution of excess food, housing, moratoria on evictions, and when they end, then what? The systems that interlock and involve landlords and mortgage holders and homeless people, regulations of congregate living, elevators and common spaces in apartment buildings. We'll look at elections, early voting, absentee voting, voter suppression issues. We'll look at schools, K through 12, higher education, and the legal rights of individuals and the obligations of institutions. We'll consider disinformation, misinformation, infodemic, labor and employment rules, tort law and duties of care by employers and others, finance and consumer protection laws, special issues confronted right now by people who face detention, whether in criminal settings or in immigration settings. We'll also consider access to court, access to lawyers, innovations during this period, whether they're temporary or permanent, and other subjects, including treatment of animals in agriculture, slaughterhouses, and police accountability, environmental and energy issues. But let's get started today. We're going to turn immediately to the subject of who decides the fundamental questions around public health during a crisis like this. What level of government? How do governments interact? What restraints are there on governments? And to start us off, I'm going to turn to Vicki Jackson, the Lawrence H. Tribe Professor of Constitutional Law here at Harvard, leading scholar of comparative constitutional law, and once upon a time, a lawyer in the Department of Justice, Office of Legal Counsel. Vicki, can governments, and if so, which governments, issue orders and enforce them that limit individual freedoms in the pursuit of public health?
Well, Martha, thank you for organizing this, and thanks for a great opening question. Let me start out with two propositions. First, it's clear that governments, state, federal, or city, can limit our freedoms in epidemics. But it's also clear that these powers are not unlimited. We know that governments can require that we get vaccinated if the medical case for doing so is sufficient. This is established in Jacobson v. Massachusetts from 1905, a case that arose here in Cambridge, when the Public Health Board required vaccination to halt the spread of smallpox. The court said a community has the right to protect itself against an epidemic of disease that threatens public safety, and it upheld the vaccination requirement as necessary to protect the public health based on, and here I quote, knowledge common to all civilized peoples touching smallpox and the methods most usually used to eradicate the disease. So that's Proposition 1. But Proposition 2, the power is not unlimited. A sense of boundaries is offered by the case law. Jacobson itself distinguished between a general rule requiring adults to be vaccinated and a situation where a particular person might be able to show that they were likely to be particularly injured by a requirement. The court said, we are not to be understood as holding that the statute was intended to be applied to such a case, or, here's the constitutional language, if it was so intended that the judiciary would not be competent to interfere and protect the life and health of the individual concerned. So this suggests that general laws, even if justified by health emergencies, may not constitutionally be applied to particular persons where doing so would be particularly injurious. In cases involving other kinds of urgent situations, the court has found that individual rights limit even presidential war powers. In Hamdi against Rumsfeld, the court insisted that a citizen detained as an enemy combatant had a procedural due process right to a fair hearing to allow the detainee to contest the designation. And as Justice O'Connor famously wrote, a state of war is not a blank check for the president when it comes to the rights of the nation's citizens. And finally, let me mention that by disavowing the Korematsu decision in Trump and Hawaii, the court made clear, I hope forever, that even in war, government cannot rely on race or ethnicity as a basis for mass detention of citizens. So, point 2, just because there's power to impose some limits does not mean the power is unlimited. 3, what's the standard of review if restrictions are challenged? Now, in many countries, a proportionality standard would apply that would look at the nature of the reasons for the restrictions, how well connected the particular restrictions are to those legitimate reasons, and whether the restrictions unnecessarily burden rights. Are they minimally impairing of rights? And do they burden rights only in a way that is proportionate to the good that is reasonably hoped to be achieved? This test has some similarities to the strict scrutiny tests applied in the United States, which look for compelling interests and narrow tailoring. The rational basis test used in the United States is more forgiving, but it still requires a reasoned and rational connection. Whatever test is used, I think, should be sensitive to the underlying evidentiary basis for the decision. What the science is should matter when it's urged as a basis for restricting rights in a public health crisis. 2 final comments. The first has to do with the who. And I want to suggest that there's a connection between rights and structural issues of who decides. Federal authority may be more limited than that of state or local governments in public health emergencies. And some of these federalism limits may actually be protective of rights. Second, executive action that might be justified or accepted in the early days or weeks after a new emergency develops may require much greater authorization from legislatures, where the broader range of public interest can be considered over time. My last comment is, I think, a challenge to our students. In the United States, it's much more difficult to enforce government duties. It's much more difficult to challenge government failures to act than to challenge government action claimed to burden a right. This is due in part to negative conceptualization of what our rights are and to related doctrines of standing. Now, some say that failures to act might be politically costly, that elections can be accountability mechanisms, but there are many limitations on the ability of voting to assure that the government upholds the law and its obligations. So I hope the next generation of constitutional lawyers will develop new ways of responding to problems of government inaction.
Oh, thank you, Vicky, for launching us so well. And let me say to all who are here, there's a Q&A feature that you can use and pose questions. We will definitely be turning to your questions as we continue this discussion. Now, with the possibility of powers and limitations so well sketched by Vicky, and also the challenge of dealing with inaction by government, I want to turn to Nico Boy, law professor, historian here at Harvard Law School, also a member of a City of Cambridge Planning Board. Nico, you are quite expert in both the historical relationships among levels of government and their current practices. So I want to ask you the same question about governmental powers and limits in the time of a pandemic, but with a particular focus on the different levels of government in the United States. Can they work together? What should be at the local level? What should be at the state level? And any historical perspective would be most welcome.
Sure. So thank you, Martha, and thank you, Emily, for putting this great panel together. I'm really looking forward to seeing and learning from all of you over the course of the semester. So in thinking about COVID and the United States' response to the pandemic, I've been thinking a lot about federalism. And federalism is a pretty dirty word among many people on the left to correctly associate it with racialized caste systems and obstruction, all captured under the idea of states' rights. And there's no point to denying or ignoring that history. But federalism is also defined by disaggregated sources of power in contrast with concentrated power. And I think the pandemic has illustrated many contexts in which that sort of disaggregation is valuable for everybody. So you can imagine a United States absent federalism, in which the only government empowered to respond to the pandemic was the federal government, so the Trump administration. And the entire first wave of the pandemic, especially in the Northeast, rose and fell, killing tens of thousands of people before the president conceded that it might be a good idea to wear masks in public. So concentrated power would have meant that the federal government had greater potential to respond. It might have been able to issue mask orders or to require individuals to do things to minimize the health risk. But concentrated power also means that bad leadership would be a mortal danger to the entire nation. But instead, thanks to federalism, state governors and state legislatures and local governments were also empowered to respond to the pandemic, especially in the early months. And all of the things they did, like issue stay-at-home orders and eviction and rent moratoria and unemployment benefits, were really important for stopping the pandemic in its opening months from really getting out of control. And we've seen a similar dynamic, not just at the interstate level, but also in the intrastate level, so within states. So in states whose governors and legislatures responded to the pandemic slowly or skeptically, local governments stepped in. Cities issued mask requirements and rent control ordinances and other immediate solutions to the crisis. Here in Massachusetts, which generally had a pretty good response, most school districts shut down before the governor acted. And local governments have been primarily responsible for developing the plans to reopen schools. And these local responses have been characterized by many of the things that make local government valuable, including the ability of interested people, so parents, teachers, administrators, politicians, to all interact with one another, and about how to balance this extremely important need to provide childcare and good educations and balance that against endangering the broader community. But I think the pandemic has also exposed some pretty important vulnerabilities of federalism. So for one thing, federalism only exists at the federal level, so the interaction between the federal government and lower governments, and only in specific contexts. So when the president issues an order promising to withhold funding from anarchist jurisdictions, which he recently defined as places that try to defund their police or that fail to invite unidentified federal agents to come tear gas people, legal commentators have laughed at him because the federal government, he doesn't have that legal authority to do anything like that. Yet the federal government routinely conducts similar arrests in the immigration context, where federalism so far has played less of a role. So it's not a coincidence that in response to this summer's Black Lives Matter protest in Portland, that federal response was conducted mainly by Customs and Border Patrol, which, despite federalism, has been given virtually limitless authority to conduct warrantless arrests of suspected non-citizens. Federalism also doesn't exist at the state level. So when Texas wanted to issue mask ordinances, the governor prohibited them from doing so. And the governor has this power because since the mid-19th century, local government law have concluded that states are sovereign and cities are not, meaning there are very few intra-state limits on what a state can do to a city. And this hasn't just affected local responses to COVID, this has affected everything. So cities that want to defund the police or change the way in which their police officers interact with communities of color, they have very little autonomy. They can't change what counts as a crime without state approval. They can't locate new sources of funding for COVID relief without state approval. They can't do much of anything without state approval. Yet the Republican Party is currently campaigning on a platform, to the extent there is a platform, that these Democrat-run cities are mismanaged and anarchic, showing that there's a really important mismatch between power to respond to things like COVID and the perception of which government should be responsible for responding. And this is going to just be a huge problem in the next fiscal year. So almost every city in this country is legally prohibited by their state from raising taxes through any means other than taxing the value of property within their borders. So as landlords, commercial tenants, people who own homes lose their jobs and can no longer pay property taxes this fall, cities around the country are going to go bankrupt. It's going to be another wave of just bankruptcies, municipal bankruptcies this next year. And so all of the essential services that local governments provide, including education, they're about to be sacrificed. And states are not in a much better position because for all the genius of federalism, the federal constitution was adopted during a recession with the express purpose of stopping states and local governments from enacting debt relief measures. So states are prohibited from abridging contracts or issuing money, which has led states to include in their state constitutions requirements to maintain balanced budgets. So states are also going to go bankrupt as people lose jobs and need to collect unemployment benefits, yet there currently does not exist any legal mechanism for states to enter into bankruptcy. So we're going to enter a situation in which the federal government is the only government that has the power to print money, to enter into deficits, and to power the country through this upcoming recession with stimulus packages and job guarantees. It's the context where only the federal government is empowered to act. But as we've seen, while concentrated power has enormous potential, under bad leadership, it could be a mortal threat to all of us.
Well, thank you, Nico. And when we return to you and have further questions, I hope we can drill down on the issues of housing as the evictions start and the bankruptcies of the landlords start. Is the federal government the only place that can act? Is there some consortia among states that can act? So we'll return to that, and I'll plant a seed for all the panelists later on. Are there particular communities that are particularly vulnerable or have particular claims for exemptions, say religious communities? But I want to turn now to Urs Gasser and broaden our scope to consider the comparative perspective, and particularly a perspective from Europe. Urs is professor of practice here at Harvard Law School and executive director of the Harvard University Berkman Klein Center on Internet and Society, and also deeply involved in the questions of governance of the internet, but governance of all kinds of issues facing society. So Urs, help us.
First of all, thanks so much. I'm delighted to be part of this opening session, and I'm looking forward to learning from all of you over the next few weeks. So the question you asked, Martha, who makes the decisions, obviously is also a puzzling question in Europe, particularly, where we also see these multiple layers of governance and actually a patchwork of legal norms that are relevant in the context of a pandemic. So, of course, something we may not discuss as often in the US context, there is some international law, the international health regulations that are directly relevant to a case of a pandemic. In Europe, we then have the European layer with a number of laws and regulations, although they're mostly focused on supporting and coordinating mechanisms. And then importantly, legislation at the national level that gives a jurisdiction and authority. So for instance, in Germany, there is the Protection Against the Infection Act that regulates public health emergency like a pandemic. And then importantly, much of the decision-making authority dealing with a health emergency is pushed down to the state levels and state laws, again, in the example of Germany, but also elsewhere. And that's flowing from the subsidiarity principle. That's a key principle across Europe. Now, of course, the problem immediately is, and I think that's the similar question that we are now struggling with in the US, how well do these different jurisdictional levels and also norms interoperate with each other? So what's the interoperability situation? And I think there are maybe just kind of two quick observations that may add some nuance to the conversation here. It's interesting to me, it seems, when focusing on the prevention of a pandemic, that the legal frameworks that have largely focused on information exchange and establishing of early warning system to detect public health risks that may be of international concern work pretty well, that we have higher levels of coordination, better interfaces at all levels that I mentioned. So in terms of prevention and information flows, I would say the legal frameworks have a higher degree of interoperability, especially when compared to what happens once the crisis hits, when there is a pandemic and these different actors have to come up with a response within, the governing legal frameworks. There, I think the subsidiarity principle that pushes decisions towards the state and local level come with significant downsides. We see fragmentation naturally of the responses and measures that are taken. For instance, do you send kids back to school or not, or what travel restrictions are imposed? And that, of course, may decrease the effectiveness of any measures, given that people flow from one, move from one jurisdiction to the other. So that's definitely a serious issue. I would say on the other hand side, the idea of subsidiarity also comes with advantages, even if our instinct is more coordination and centralization in terms of coordination of measures may be meaningful. And I would say particularly in later stages of a pandemic, you could see the benefits of more local decision-making, because the advantage of local decision-making is that the authorities locally are closer to the context of what's happening on the ground and are often more, are faster to respond to new clusters of infection, to give an example here. Now, one interesting question for the future, I think, almost kind of a legal design challenge for the future, also looking towards our students, is how can we become more agile within law while still, of course, understanding requirements like the rule of law and legitimacy and transparency, that jurisdiction may actually be assigned more dynamically. One great example is actually Switzerland, where it's my home country, where we have a relatively new law that regulates epidemics and other public health crises that has an interesting mechanism, which is to say, at a certain level, when there is a national health emergency, the usually by default local authority is centralized with the federal government. But as the health emergency de-escalates, the authority for decision making is gradually flowing back and going back to the local entities, to the states or cantons in the Swiss terminology. And that to me is an interesting mechanism that may signal a way to not just, make these binary decisions, is it centralized or decentralized, but for certain cases like a pandemic, to create a legal innovation, an innovative mechanism to deal with these issues, so that you get the benefit of coordination at the moment of a crisis when you need it, but then also can turn back to more local decision making to embrace the benefits that I mentioned of understanding the local context, and of course also to go back to the default, what the Constitution may stipulate. So I stop here and turn it back to Martha.
Thank you so much. And maybe we'll have a chance to ask you if some of the similar issues that Nico raised about financial limitations on the locales for raising money arise in Europe, or is there some other mechanism for dealing with that? So I want to turn to Jonathan Zittrain, who's the George Bemis Professor of Law and Director of our library and the Berkman Klein Center, and on the faculty of the Computer Science School and the JFK School. And Jonathan, I wonder if you can help us either with the example of contact tracing or anything that you've been tracking here to help us explore these issues about who decides, is there coordination, and is there any way to improve the cooperation across different levels of government in dealing with a pandemic? Just as an aside, I'll say that I've worked on the issue of emergencies elsewhere and discovered that lawyers are rather alone. Every other profession, every other industry regularly works on emergency planning and thinking ahead and are part of coordinated teams to do this. I think the governments are beginning to do it partly because of the issues that climate change is raising, but as the pandemic exposes, particularly in areas where there are low-income communities and other marginalized groups, this preparation work has not been done. So with that wind up, JZ, what can you tell us?
Well, thank you, Martha, and great to see my colleagues, even if only through a webcam, thanks to the pandemic. We get used to it all too easily. And I think you're right in identifying some of the differences by profession and how different professions are looking at things. The lawyers, we're starting by asking questions like, okay, well, what are the authorities here? Who are the, what are the sources of authority by which government can act to protect everybody? And how do you coordinate among different government entities and fill the gaps if one or more elements within a federalist or subsidiary system starts to break down? And that tends, as you say, not to be so much a preventative thing, but just a how can government react flexibly as new threats arise and become priorities. And I think I compare that with the public health outlook, which formally is sort of how do we protect the common good, not as much a concern about individual rights, unless it's a right to health within a community. And that is against a backdrop of, within the United States, a kind of public health establishment that has become so used to being chronically underfunded, whether in good times or bad, that they, I think, are not used to demanding or asking for more. I forget who it was who mentioned that Delta Airlines is getting a bigger bailout than any of a single state public health authorities to actually deal with the pandemic, which is itself, of course, a statement of priority from the federal government. Other professions include the tech people, including the Silicon Valley types. And a lot of them, understandably, you know, they scorpion will sting, or sort of, well, what gizmos do we have that can make all of this go away? Give me an app. And I find myself actually open to that. I'm interested in just how much of a surveillance framework privately has been built, not through government of the sorts that our students often will study in Fourth Amendment, but through private industry, which is not so bound in what it can extract. And if we're using it to figure out how to target just the right ad for Domino's Pizza at the right time, why wouldn't we possibly be wanting to deploy it, whatever protections we want to put in for privacy, to do something, as you say, like contact tracing? And I'll just leave that open for a minute and turn also to the economists as a profession. And I just want to note that among our economist colleagues, there's something of a debate going on about how do you support people and businesses, et cetera, to try to get to this so-called V-shaped recovery, with other economists pointing out that get the virus under control, pointing to the public health people, get that fixed, and the economy is then reparable. But if you try to reverse the order and open up too soon, you just end up with more pain later on. And then I think there's a profession I'd call citizen. And for the citizenry, especially when this was brand new, you had everybody's attention by and large, saying, all right, well, what should I be doing? And who can I trust to tell me what I should be doing? And the amount of goodwill and energy that could be harnessed to mitigate the effects of the pandemic among the citizens themselves, the ultimate subsidiarity down to the individual, the people themselves, that was completely squandered by the federal government and the federal leadership, and continues to be to this day, as mask wearing is turned into a culture war issue, as vaccines might be touted before they're ready, and on the other hand might be denigrated. These sorts of things, I think, are drastically affecting our ability as a society to deal with this problem. And we don't, as lawyers, have much of a framework for accountability there, except, I guess, the ballot box at the end of the day. And you just brought up contract tracing an example, and I'll run through it real quick. We started a group at Berkman Klein, of which many of the people here are members, in March, trying to look at, all right, how do we get contact tracing going? What can we do digitally to assist it? It having been a traditional function done in a very analog way. Think fax machines from one public health authority to another. In Massachusetts, there's over 250 of them because it goes by town and very much local jurisdictions. And the idea is to be able, once you do have somebody who's known to be positive, to tell them that they need to isolate, and to figure out who they've been in touch with over the past 2 weeks that might have been exposed, and therefore they should get tested and see if indeed they could be transmitting it themselves, and in the absence of a test should be quarantined so that they can't further spread it. And that very simple concept that could be assisted by technology has itself not delivered much on promise yet, because we haven't taken the steps legally, policy-wise, and as a society to get the case numbers low enough in many areas that being able to do this sort of individual follow-up can stamp out the embers. And it's also kind of gotten us to a point where there's no support if you isolate. I mean, what does it mean to say, oh, you can't go to your job? You have family in your house? Are you supposed to stay away from them? The sort of holistic drawing together of a confident map with leadership that can say, this is what we're trying to do and how we're trying to get there. You're absolutely right, Nico and others, that state governments have been trying to fill the gaps to varying degrees. I'm just amazed at how much the governors of, say, Massachusetts and Maryland have had to spend energy securing their own supplies in competition with other states in just an open market where, of course, any economist will tell you there'll be price gouging. It's not a natural market. And where if you have an open line to Jared Kushner and say the right magic words as somebody running a large hospital chain, that might get you more protective equipment for your staff. This is no way to run a country. And trying to figure out exactly where to impose accountability as, again, the lawyers, I think we are way far behind. We have not encountered this level of multiple problems at multiple layers, including a public that now feels like it can't really trust anybody for quite a while. I'm sorry to be so pessimistic in my account, but that's where we stand right now. Oops, you're still muted, Martha. Oh, you're still muted.
Thank you, Jonathan, very much. And I've learned from sitting in with some of the sessions with you that each government, its state and local governments, are having to invent and reinvent their own standards about such issues as contact tracing, procurement. And so even if we had coordinated leadership at the federal level, we don't have the preparation work that's needed. We're going to turn now to Noah Feldman, who is the Felix Frankfurter Professor of Constitutional Law and leader in constitutional law generally, editor of leading casebook and regular commentator in Bloomberg News, has lots to say about all of these aspects. So, Noah.
Thank you, Martha. Thanks all of you for a really fascinating conversation. And I think for those listening, you got a pretty good insight into the range of ways that law professors engage with hard problems. And you saw some of the themes that we're obsessed with. You know, one of them is what I often tell people, the two-word question that characterizes a Harvard Law School education most fundamentally. And that two-word question is, who decides? And you might think that however many thousands of dollars we're now charging our students is a lot of money to learn at the end that you should always ask that two-word question in every situation. But that is, in fact, one of the most powerful things that lawyers can do. And you heard many versions of engagement around that all-important question. I think so much good has been said about that I want to focus on two other questions that are also really fundamental to what law is, and ask both of those in connection to what's been going on in the course of this pandemic. And those are, first, why does anyone obey the law? Why does anyone ever listen to what the government says to do? And the second question is, how and does law manage social conflict? And I want to say very briefly that both of those have been deeply implicated in the course of this pandemic. So first, why does anyone ever listen to the law? Judging by European standards that Urs was mentioning, the United States has a really weird feature in this pandemic, which is that we've had extremely little law. The federal government has issued basically zero commands or orders, and it could have. Congress could have authorized the president to do a whole range of things. The president could have done some of the things within his own legal authorization that he already has. That's a little constitutional piece. He didn't. Instead, what we had were a series of orders by state governors until eventually they came out, they were rolled out slowly and they were cut and pasted often from each other until eventually just about every state had one. And those orders usually only run a page or two or three or five. And they basically said, shut down the following kinds of businesses up to a certain size. And then it gave a list of exempt businesses. And then it said, sometimes in some states, wear masks. Once in a while, there are local governments that have done something similar. The city of Cambridge, of course, had to jump into the fray, and it required a mask with a $300 fine attached before anyone else did in the state. But that's basically the legal framework that's been governing the entirety of this pandemic in the United States. And rather remarkably, go out on the streets in most places in the country, many people, not all people, many people are listening to those directives. Why? Why are people listening to those directives? Now, again, I want to make the point that in some places people aren't, but because we get a lot of news coverage of the handful of incidents where people are not following the guidelines, we tend to overemphasize the degree of non-compliance that exists. Because it's not news if people are staying home, it's news if people are out on a beach or in a bar and getting sick. So I think that part of the answer so on this question of why do people obey, one standard answer is people are afraid of punishment. And I don't think that could sufficiently explain the degree of obedience that we've seen in this instance. And the reason is simple. Most governments aren't enforcing the regulations. Walk out into Cambridge, Massachusetts, and you will see plenty of people walking around without masks, and notwithstanding the $300 fine. And as far as I know, and I looked it up before coming on today, and I wasn't able to find anything proving to the contrary, I could be wrong. I don't think the city of Cambridge has issued any citations to people for not wearing masks. I'm talking about people walking around on the streets. And I don't think people are being arrested for it or stopped. And I don't think much of that is happening anywhere in the country. I think people are listening to the guidance, including the legally binding guidance in principle, because they see themselves as part of a collective, and they're trying to act more or less responsibly by their own lights under those circumstances. Now, that's a pretty radical thing to say with respect to why people follow the law. It's not a standard view in all pieces of academic literature. It is absolutely represented, especially in European context, where we imagine, at least in our imagination, societies with high solidarity, where people feel like they're all pulling for the same team, and they're committed to some set of collective objectives, and they follow the law just because it's the law. That's the phenomenon I call, walk home drunk from a bar in Berlin at 3 a.m, and you'll see drunk people stopping at red lights when there are no cars coming in any direction. Why? Because the law says you shouldn't cross against the light. So people follow the law. So that's a phenomenon that we're familiar with in that context. We don't usually think of it in the United States. And it's somewhat remarkable that under these crisis conditions, there seems to be a huge amount as a percentage of the total of law following or rule following at a time when the law is not effectively being enforced at all. That's the first point I want to make. Whether that's a positive point or a negative point is in the eye of the beholder. You could think if you think the laws are good, you usually like the fact that they can be enforced by this kind of collective unwritten contract. If you think the law is unjust, that's a bad thing. So it's not inherently optimistic or pessimistic. The second point I want to make has to do with something that's almost the opposite side of the spectrum, and that is the depth of social conflict that we have in our country over this pandemic. The pandemic came at a moment of deep social and political division in the United States, and it almost immediately was layered onto that political division, not only because it was an election year, but in part because it was an election year. And consequently, many people's, and polls bear this out, many people's views about the underlying facts, the underlying scientific facts about the pandemic, many people's views about the value judgment, about how bad it would be to get sick, and under what circumstances we should get sick, and many people's judgments about what policy should be adopted as a result of the combination of contested facts and contested social values, so that people's ideas about what the policy ought to be are also powerfully affected by where they come down on the spectrum of views bounded at either end of this social conflict. Now that's fascinating too, and it was not predictable in advance that it would go this way. I do not think, and I reject firmly the idea that the liberal point of view is the scientific point of view and the conservative point of view is the unscientific point of view, even though that's being said many, many times by many, many people. I don't agree with it at all. I think that where law comes into this is that law is in many ways a tool for managing social conflict. That's not all that law is for. Law also aspires to do the management of social conflict justly. In fact, the basic proposition of most legal systems is that if we can engage in justice, that will help us to manage social conflict. So it's not just about the management of social conflict, it's how you manage the conflict. Do you manage it justly? But a crucial component of that is just the fact that you can manage it. And there, I would say that our legal system is managing all right, maybe partly by not bringing people to court. One of the reasons people aren't being arrested and prosecuted for violating quarantine laws or other laws is that there's a worry by authorities that would drive too much social conflict. But it is striking that notwithstanding that we're having this pandemic and deep social conflict over the pandemic simultaneously, that for the most part, that has been managed. Now, what's the counter view? The counter view is to look at the way that peaceful Black Lives Matter protests have been transmuted through a range of factors, partly through provocation, in some cases through individual acts of violence, into partly sometimes through government provocation, have been transmuted in some instances into non-peaceful, into events in which there are peaceful protesters, but there are also some people acting non-peacefully, if I could put it that way, trying to put it as neutrally as I can. And one could look at that and look at not just the shooting of Jacob Blake in Kenosha, but one could look also at the subsequent shooting by Kyle Rittenhouse of 3 people, 2 of whom died, and say, what are you talking about, Feldman? Our social conflict is coming out into the streets. My response to that is to say, I'm not going to dispute that at all, but that's a form of social conflict that is not primarily pandemic related. I don't want to say it's unrelated to the pandemic, pandemic makes us all a little, it emphasizes whatever strong social conflictual feelings we have. But that has not been the recurrent phenomenon. In fact, we've seen since the beginning of the pandemic, both left and right engaging in major public protests, despite the potential dangers of transmission of the virus. I think that with respect to the social conflict that we have around the pandemic, our legal system is managing modestly well to manage that social conflict. If the election goes south and we, a week after the election, we still don't know who the president is, that could change. I'm not arguing that the system is perfect. But I do think it's worth noting, and in this point I am being modestly optimistic, that the management of social conflict function of the law seems to be more or less functioning right now with respect to the pandemic itself.
Thank you, Noah. So interesting. And your use of the word manage is, I think, well chosen, because there's no pretense of resolution. It is a negotiation. Cambridge is such a good example. My understanding is that Cambridge as a municipality has decided not to use the sanction that it has authorized, but it instead has deputized a series of workers who go out and nudge people, who talk with them and say, would you wear a mask? Here's a mask, would you wear it? So there are different ways that government can manage besides punishing people. And I think that amplifies your point. The issue of conflict and division is very much coming up in the questions that I'm seeing. And one kind of division in the country is between cities and urban and rural areas, or even suburban areas. And that may reflect income, may reflect race, but in any case, there are distinctively different politics in urban areas in the United States as well as compared with elsewhere. So one question that's come forward specifically to Professor Bowie, but anyone can answer, is what can a city do when a state prevents it from, for example, enacting a mask ordinance as in Texas? What is available, and does the federal government have any authority to step in on behalf of the city? And if I can elaborate, what should we consider about the issues of social conflict when we have pronounced conflicts or divisions between cities and the states in which they inhabit? So, Nico, can I ask you to begin?
Yeah, absolutely. So there are two responses to the question of what can cities do when states try to disempower them. There's a legal answer and there's a political answer. So legally, not much. So the way in which local government law has been interpreted to operate in virtually every state, there are simply very few legal safeguards for the typical city when a state legislature wants to disempower it. And so even before COVID, we've seen examples of Birmingham, Alabama passing a minimum wage ordinance that the Alabama legislature says, nope, can't do that. Or a state passing, or a local government passing a ban on Uber, or Cambridge recently tried to make it more difficult for delivery services to charge, super high fees of restaurants and bars that wanted to, for Cambridge to intervene and say, have a law saying you can't charge 50%. Massachusetts says, no, you can't do that. So there are lots of examples, and the legal framework is one disempowerment. That said, politically, we live in a world in which we live in a country rather, in which there are very few formal institutions by which communities as a whole organize and exercise political power. So one example throughout most of the 20th century were labor unions. Today, union density is at its lowest point in decades. And local governments have actually become advocates for communities in electoral politics in a way that unions were once the predominant example. So in most states, local governments have the power to lobby. Local governments have lobbyists in DC. They represent a huge chunk of the lobbying market. And the federal government can step in and say, we, the federal government, are going to allow cities to do X, Y, and Z, even if a state disagrees. And there have been examples of that in the context of broadband. I would imagine there will be examples in the future if states continue to disempower cities in a response to COVID, where the federal government might step in and say, cities, you do have the power to pass a rent moratorium on that affect interstate commerce, or cities, you do have the power to issue a mandate to the extent that it affects something within the federal government's wheelhouse. So I think cities as a political unit are very powerful. In most states, we now see like democratic cities fighting against rural and suburban, like purple suburbia and red rural areas. And that will affect what kinds of laws states and the federal government pass over the next few years.
Thank you so much. You know, it's striking to me that there are other actors besides the official governmental ones. And there are the possibility of roles of scientists, as Jay-Z mentioned, and also business leaders who might help to broker some solutions or some resolutions when we have conflicts between these different governmental entities. In addition, depending on the abilities of particular leaders, there might be persuasiveness or communication, not only between the leaders and their communities, but among the leaders themselves. And that's at least another avenue to think about. There's a question I put to all of us from the group, which is, how are the legal authorities and responses we're discussing making inequality or disparities better or worse? Who'd like to try that one? Noah, would you give it a try?
Yeah, sure. I can say something, sure. So, you know, that's a great question. And to start answering it, you have to begin with the observation that COVID-19, as it has spread, has revealed and relied upon pre-existing fundamental social inequalities in the United States. So those, roughly speaking, could be grouped into two categories. One, that the way people live physically, that is to say the density of where they live, is to a great extent inflected by their socioeconomic status, and that socioeconomic status is in turn inflected in the United States by other forms of inequality, predominantly racial inequality, but also economic inequality that goes alongside it. And so if you lived, as in Massachusetts, if you lived in Chelsea in dormitory style housing because you were a low income worker and often a recent immigrant, you had vastly higher chances of getting the disease. The second, broadly speaking, feature is that because in the United States, health results are highly inflected by socioeconomic status and via socioeconomic status by race, the fact that people who had underlying health conditions were more likely to die if they were to become infected with COVID-19, then reflected a higher percentage of COVID deaths among poorer and typically African-American, also Latino, but African-American communities in a greatly disproportionate fashion. So those are roughly the two. So just starting by naming the two major forms of social, economic, and racial inequality that have most powerfully affected the spread and then the effects of the disease, so two different elements. Interventions in response have, I think, been aware of that phenomenon at the level of public health intervention and have really struggled with the ethical problem of what to do about it. So in the first instance, there's the ethically straightforward issue, which is if certain communities based on their geography are more likely to be affected by the disease, it makes sense to devote more resources to fighting the disease in those communities. In some instances, that's been done almost by necessity, and not particularly necessarily out of any great ethical impulse, but out of the fact that when you're dealing with a pandemic, you want to avoid as many people as possible getting sick in order to protect people who aren't sick. And if poorer people or people who are Latino or Black or poor are getting sick, then it's in the self-interest of the majority white, more affluent world, maybe not the majority, but the white or more affluent world to avoid, to reduce the number of illnesses to protect themselves. That's a cynical account, but it's not unreasonable in this context. That said, because this is the third dimension of inequality, because healthcare services are already less available at comparable quality for poor communities, and especially communities of color, the treatments themselves are also differentially available. So, emergency responses have been made that have attempted to be in some mitigation of this disparity. Again, not necessarily out of anything other than self-interest. But they're typically involve devoting resources to under-resourced hospitals and physicians. And so I would say that the limitation has therefore, the effects have therefore been relatively limited. And that's observable in the fact that over the course and trajectory of the pandemic, the disproportion in who's getting sick and who's dying hasn't really changed markedly. It has evolved a little bit, but if you look at places which are getting the disease now, as opposed to places that were getting the pandemic 3 or 4 or 5 months ago, the ratio of people who are becoming ill and who are dying remains genuinely disproportionate when measured by socioeconomic status, economic status, and race. So, have the interventions made that worse? This is my last point. That's unclear. I don't think there's enough data to definitively answer that question at this point. There was a lot of worry at the beginning that targeting communities of color and poor communities would lead to stigmatization, and that stigmatization would in turn further enhance the degree of injustice that already exists. And many, many public health officials whom I worked with throughout this have been very, very concerned about that. And it's a genuine concern, but it always has to be balanced against the necessity of targeting the communities where COVID-19 is disproportionately likely to exist, to spread, and to do extra harm. So that's a very, very delicate trade-off. And I think in many cases, public health officials have tried to balance it, but it's sort of one of those situations where there isn't going to be a perfect solution.
Well, thank you for that. We're going to see those exact considerations underscored when we have a vaccine or multiple vaccines, which I'm sure we will within 12 months, if not before. Who gets priority? Who gets priority access? What's the allocation? Should it be particularly targeted for the communities that are disproportionately affected? Is it going to be distributed by money? How are we going to do that? So I'm going to ask you all to think about, as a closing question, what one thing could be done now to prepare for the next pandemic that lawyers and legal systems ought to be doing. And as I do so, I'm going to just celebrate the blog that's accompanying this series, available at covidseries.law.harvard.edu, where this and other recordings will be posted, along with other resources and I think instructive and illuminating posts on particular issues. So what one thing could be done? JZ. Are you there?
JZ, you're muted now.
Sorry about that. I'll try to take 2 quick bites at the apple. The first would be, when we're not in the thick of it, to have in place concrete principles around allocation of scarce resources, whether it's PPE or a vaccine or other intervention, the way in which it can become fraught in the best of times and just rank patronage in the worst of times seems to me something to be able to lay out ahead of time and be a way of being true to Noah's observation of answering the question, who decides? And to actually have some sense ahead of time who's going to bear what responsibility within the system would be quite good. And the other intervention I would think of would be, it's kind of maybe a spin on this federalist idea, but it's what are the roles of the private intermediaries, of which there are only a handful that have substantial reach, like a Facebook and a Twitter, in shepherding information flows, and in particular, dealing with misinformation against a backdrop of totally justifiable skepticism of having private parties decide what we're allowed to see and in what order. Why should they're not in the business of being experts on microbiology. At the same time, what we see is going to be determined by them if we're using their services, and the rate and penetration of misinformation and disinformation through those services is such that I think full abdication doesn't strike me as such a great idea. And figuring out what processes, whether they're governmental, non-governmental, or some middle zone, by which we can determine ahead of the next pandemic what the policies are going to be around information flows, and something just recently coined by one of our affiliates, mid-information. When science is understandably confused and can't be authoritative, that creates a huge vacuum, and if done wrong, a breach of trust between the public and the scientific establishment. So figuring out information flows through private entities seems to me the other big intervention.
Our colleague in the English department, Elaine Scarry, has a wonderful book called Thinking in an Emergency, which fundamentally can be summarized as you can't. So we have to do the thinking in advance. And with regret that we can't pursue all of the questions that have been addressed here, I'll just flag a few. What about people with disabilities? What about domestic travel? What about the ways in which there are ethical issues that aren't captured by the law? Many, many other issues. And for that, I hope that you all, panelists and attendees all, continue the conversations, come to the blog. I want to thank you all for participating, especially our terrific panelists and our behind the scenes team, Jeremy Dang, Ellie Benet, Emily Broadleaf. Thank you so much. Thanks, everybody.